AK 65, 2018.
Got it.
And 2 others. I think 1 is and 2 others. Okay. And Dr. Abdul our Ibrahim and 3 others. AK 65, 2018. Any appearance?
With the greatest respect, my lord.
Yeah.
My name is Ademola.
Your name is who?
And with
I'm not sure
Ademola, Ademola.
I'm not sure this is your case.
Oh, okay.
This is AK 65, 2018.
Oh, okay. I'm sorry, sir. Yes, that's true. It's not my case. I'm sorry, sir.
May it please my noble lord.
Yeah.
My own
May
is
it please my noble lord.
AK
Yes.
Ayodele Olubodun.
58 names.
Ayodele
Olubodun.
Yes.
I announce my open appearance for the claimant, sir.
Yes. Yes.
I don't know how we're going to do, but
May my noble lord be pleased.
Yes.
I'm A.S. Bar. I appear for the first defendant, my lord. I'm most obliged.
Yes. Yes. Second defendant, counsel. Diko.
Yes, sir.
Get the last adoption. Adoption.
It has to hold.
And for the third defendant, BC. Okay. The matter is for judgment. And this is
Hello,
the judgment. Sir. Yes.
My lord, I don't know whether the court heard my announcement, sir. I am BC Atolagbe for the third and the fourth defendants. BC Atolagbe for the third and the fourth defendants, sir. What your place, sir?
So the third and fourth defendant
is represent.
The third and fourth defendants are now second and third defendants, isn't it?
As court pleases.
Although, well, it will remain like that because we simply struck out their names at the last adjourned date. Isn't it?
Yes, my lord.
Yes, my lord.
second defendant.
The judgment.
Okay, the matter is for judgment, and this is the judgment of the court.
Stop, please.
Go places.
Stop, please.
The claimants took out a representative action via a complaint on 7th February 2018. The first and second defendants filed a memorandum of appearance and a notice of preliminary objection on 2nd April 2019, and by a motion of 22nd May 2019 filed their statement of defense. The claimant filed a counter affidavit to the preliminary objection on 8th April 2019. By a motion filed on 20th May 2019, the third defendant obtained leave to file a notice of preliminary objection and a statement of defense. The statement of defense was filed on 27th May 2019. The claimant filed a joint reply to the statement of defense of the first, second defendants and claimants on. Second defendant filed a separate statement of defense on 11th March 2021, and the claimant filed a reply thereto on 17 March 2021. The first defendant filed filed a separate statement of defense on 15th March 2021, and the claimant filed a reply thereto on 17 March 2021. By a motion of 23rd June 2022, one Otunba Babatunde Morakin Yosot and obtained leave to be joined as the fourth defendant. Memorandum of appearance and statement of defense were filed on 24th June 2022, and the claimant filed a reply thereto on 6th December 2022. On the 12th October 2023, the name of the second defendant was struck out. Claimant's sole witness, Aliu Umar, that second claimant, on the 2nd December 2021, adopted his witness depositions of He adopted his witness depositions of 7th July 2018 at pages 14 to 24 of the court file, and his witness deposition of 26th June 2019 at pages 433 to 436 of the court file. These are the witness statement on oath accompanying the complaint and the witness deposition in support of the joint reply statement of defense of the first, second, and third defendants. Claimants replied to the statement of defense of the fourth defendant filed on 5th December 2022 had no witness statement. It is the case of the claimants that the claimants and the 53 others named in the attached table Okay. It is the case of the claimants and the 53 others named in the attached table of salaries. It is the case of the claimants that the claimants and the 53 others named in the table of salaries are staff of Famous Integrated Resources, a business name registered under the Corporate Affairs Commission. That sometimes in 2004, One Infinity Segments Limited was appointed as revenue advisor to the Kwara State government, and we, the claimants, were all employed by the Infinity Segments Limited as staff for that purpose. In 2009, the business relationship between the Kwara State government and Infinity Segments Limited was terminated, and a new set of people trading under the name and style of Primus System Enterprises Communication International took up the business of revenue advice and collection to the Kwara State government. The claimants were inherited by Primus System Enterprises Communication International, who later changed its name to Famous Integrated Resources and issued them appointment letters for a fixed term from 1st July 2014 to 31st December 2019. That on 6th January 2017, the third defendant informed them to stay back at home pending the completion of an internal reorganization of the management team of the company. The defendants have since then failed to recall them or to pay their salaries in spite of a demand letter from their solicitor and have not disengaged them. The claimants computed their entitlements from 2015 to October 2018 as tabularized, amounting to a total sum of 86,954,026 naira 5 kobo. Case of the defendants. At the hearing, the third defendant, Mr. Modashiru Akintola, testified for all the defendants. He adopted his witness depositions of 24th June 2022 at pages 691 to 699 of the court's file, and his witness depositions of 24th July 2022 at pages 661 to 668 of the court's file. It is his case for the first to third defendants that he was the managing director of Famous Integrated Resources, that he was a managing director as an employee, not as a promoter or co-founder, that the claimants and all other persons they represent were not staff or employees of Famous Integrated Resources as at the time this suit was filed, that the establishment known as Famous Integrated Resources had ceased to exist as at the time of filing this suit. It was removed from the Register of Corporate Affairs Commission on 29 August 2018. That the registration of Famous Integrated Resources was only for the purpose of provision of services rendered to Kwara State government, and it never carried out any other business till its name was removed from the Register of the Corporate Affairs Commission. Paragraph 6 of the claim as to employment for a fixed term from June 2014 to December 2019 is admitted only with respect to the first, second, and third claimants. The employment of the claimants and all other persons employed by Famous Integrated Resources were terminated upon frustration of the engagement for which they were employed. That the Kwara State government, through the Ministry of Finance, terminated its contract with Famous Integrated Resources through a letter dated 8 April 2016. The firm informed its staff of this development and also informed the staff that their disengagement will be deferred till December 2016. In December 2016, at a meeting, all the employees were informed of their disengagement and issued notice of termination individually, but most of them refused to acknowledge receipt of the notice of disengagement issued to them. Testifying as DW2 for the fourth defendant, his testimony is the same in all. Okay, DW2 is sorry. Akin Kola Moda Simo. Sorry. Testifying as DW2 for the fourth defendant, the testimony of Akintola Mudasimu is the same in all material as for the first to third defendants and shall not be repeated herein. This witness was also cross-examined. In spite of presenting one witness, the first defendant filed a final written address on 6 January 2023. The second defendant filed a final written address on 21st June 2023, and the third and fourth defendants filed a final written address on 10th October 2023. The claimant filed a final written address on 13th April 2023. I have read the final written addresses. Each counsel argued in favor of his client's case. Court's decision, A, preliminary objection of the first defendant. The first defendant counsel filed a preliminary objection on 2nd April 2019, asking the court to strike out the suit for being incompetent and disclosing no reasonable course of action. The grounds are that the employees have separate course of action which cannot be combined in one course of action. Of separate courses of action which cannot be combined in one course of action, that the claimants do not share a common injury and are not seeking the same relief, that the claimants have failed to disclose a reasonable course of action against the defendants. In support is an 8-paragraph affidavit and a 10-page written address in which counsel advanced arguments in support of the above grounds. The claimants filed a counter affidavit on 8 April 2019 in a 19-paragraph count and in a 19-counter affidavit. 1AS Oladimeji deposed to the contrary of what the first defendant contends. Attached is a 9-page written address arguing the contrary of what the objector argued. The claimants herein have the same course of action against the defendants, which arose the same date, and indeed it will amount to a waste of precious judicial time to file separate actions only to come and repeat the same story, as none of the claimants have a different story to tell, and the claims are monetary and for the same period of time. For the same period and length of time. The guiding principles of representative action is that all the claimants must have a common interest and grievance in the suit, and the relief sought beneficial to all of them. See Dover Hotel PLC and Mr. Abela Itiok and others, 2010 LPELR 4064 Court of Appeal and Nigeria National Integrated Power Project versus Akure, 2021 LPLR 54208CA. The suit of the claimants meet all these requirements. On reasonable course of action, the case of the claimants is that they were employed, they were asked to stay at home for some time, they could not look for alternative employment since they have not been disengaged. They have not been disengaged, but have not been paid their salaries. This is sufficient and reasonable course of action if proved. The preliminary objection fails and is accordingly dismissed for want of merit. B, merits of the case. I have read the processes and the final written addresses of counsels, and I am of the view that the loan issue for determination is whether the claimants have proven their entitlement to any of the relief sought. In a civil case, matters are proven on a preponderance of evidence. See Chukwu Construction Company Limited versus I.O. Uwecha, 1999, LPELR 5508CA. The first burden of proof of any particular fact in issue lies on he who asserts or alleges the positive, whether claimant or defendant. See Section 136 of the Evidence Act 2011 and Chief Anthony Uka Ekpakora versus the Governor of Lagos State and others. 2019 LPLR 50716. In this case, the burden of proof of employment lies on the claimants, and they have discharged it by Exhibit SLK 21 to 52. Actually 51, because L 51 in number. Actually 51 in number because SLK 28 is double. We accordingly have only 51 claimants on record and not 56 claimants. The claimants have also shown that all the defendants are the promoters or owners of or doing business as Famous Integrated Resources. The claimants have also shown that they were neither disengaged nor paid salaries from January 2017 till the filing of this suit. Having prima facie established their case, the burden of proof now shifts to the defendants to disprove the claim. In their defense, it is the case of the defendants that only the three named claimants are their staff, but the defendants have no answer to the 51 letters of employment tendered in evidence as SLK 21 to 52. The defendants have failed to report the fact of employment of these 51 claimants whose letter of employment by the defendants have been tendered and admitted in evidence. Secondly, it is the case of the first to third defendants that PW3 is neither a promoter nor a co-founder of Famous Integrated Resources. There is also no evidence before the court, particularly in this case. It should have been either the certificate of registration of Famous Integrated Resources with the Corporate Affairs Commission or the third defendant's letter of appointment by Famous Integrated Resources. To show that the third defendant is only a staff and not a promoter or a co-founder of famous integrated resources. This line of defense also fails, and I find that the third defendant is a promoter or a co-founder of famous integrated resources. Thirdly, it is the case of the defendants that the Kwara state government, through its Ministry of Finance, terminated its contract, for which purpose the claimants were employed, by a letter dated 8 April 2016. There is no evidence of the letter dated 8 April 2016 from the Ministry of Finance, terminating the Kwara state government contract with famous integrated resources. This line of defense also fails. Fourthly, it is the case of the defendants that the claimants were issued letters of disengagement on 6th January 2017, but most of them refused to acknowledge receipt. This implies that a few acknowledged receipt. As a proof of such refusal, the defendants were expected to put in evidence the acknowledgement copies of the few who acknowledged receipt of the letters of disengagement. There is no evidence of the notice of disengagement as supposedly acknowledged by few, since it was not all of them, but most of them that refused to acknowledge receipt of the notice of disengagement issued to them. There is no evidence of the notice of disengagement supposedly acknowledged by few, since it was not all of them, but most of them who that refused to acknowledge receipt of the notice of disengagement issued to them. The acknowledgement copies are ordinarily to be in custody of the defendants, and failure to produce them amount to withholding evidence and should be resolved against the defendants. See Section 149D of the Evidence Act. The fifth point in the defense is that famous integrated resources had ceased to exist because it was deregistered on 29 August 2018. The proof of this ought to be the instrument or notice of the registration. There is no such evidence of the registration presented before the court. There is also no evidence before the court that famous integrated resources had ceased to exist, or that it was removed from the register of the Corporate Affairs Commission on 29 August 2018. Without these proofs, the defense of the defendant fails in its entirety, and I so hold. The claimants have established their claim against the defendants. What is left to be determined is the extent of the claimants' entitlements. The claimants computed their entitlements from 2015 to October 2018 as tabularized, amounting to a total sum of 86,954,026 naira 5 kobo. There is nowhere in the statement of facts that the claimants averred that they were not paid for the period of 2015 and 2016, except as from January 2017. The court can only grant what is pleaded and proven. The court can grant less, but not more. See Ajayi versus Texaco Nigeria Limited, citation supplied, and Akure versus Delta Steel Company Limited, citation supplied, where it was held that the relief granted must be claimed in the pleadings and proved at the trial. Similarly, the introduction of leave bonus, 13 months salary, end of year package, productivity bonus, and pensions contributions introduced in the table are not covered by pleadings. These claims are not proved and not grantable. See Amosun and INEC citations supplied, where the Court of Appeal per Garba JCA held as follows. Without the need to waste much verbiage, I would state that the learned counsel for all the respondents are right in the submissions that a party cannot claim a relief or reliefs in vacuum, and that any relief claimed in a case must relate to, arise from, or based on the facts set out in the pleadings of the party. The facts averred in the pleadings are the foundation from which any relief or reliefs in a case must be built and based. Otherwise, the relief or reliefs would have no legs to stand in law. Specific reliefs cannot therefore be claimed without the relevant facts in the pleadings which ground them. Being a fixed contract, I hold that the claimants are ordinarily entitled to their annual salaries as per their letters of employment, exhibits SLK 1 to 52 from January 2017 to December 2019. However, the claimant's demand for prayer stops at October 2018, and the court cannot grant more than what is asked for. See Ajayi and Texaco citations supplied, Akure and Delta State Company Limited citations supplied. Accordingly, it is hereby declared that the claimants are entitled to their annual salaries as per their letters of employment, as with SLK 2, 1 to 52, from January 2017 to October 2018, a period of 20 months. We shall calculate this. We shall calculate this by dividing the annual income of each claimant by 12 to get the monthly salaries, then multiply by 20 to get 20 month salaries. As earlier indicated, the letters of employment presented in evidence are only 51 in number, as represented by exhibits SLK 21 to 52. So there are only 51 claimants, contrary to 56 claimants as suggested by the complaint, which names 3 claimants as suing for and on behalf of 53 others. The defendants are hereby ordered jointly to pay each of the following 51 claimants as follows. 1. Ishola Oladimeji. After the calculations are all there, but I will state just the total amount, but the calculations are done there. Ishola Oladimeji, 980,000. Aliu Usman, 220,000. Olagunju Abraham, 220,000. Windiran Shola, 656,000. Bello Abimbola, 656,000. Salo Sahid, 809,000. Saka Ayodeji Ismail, 809,000. Joseph Abolarin, 809,000. Ajibola Roslyn, 380,000. Babalola Alex Olalekon, 580,000. Oni Adebola, 380,000. Saliu Akano, 572,000. Aderemi Moses, 572,000. Hamid A. Rashim, 572,000. Daramola Rotimi, 572,000. Lawal Ariyo Nuruddin, 656,000. Oba O. Zainab, 656,000. Musa Falsat, 656,000. Abolarin James, 656,000. Tiamiu Abdul Rashid, 656,000. Senibi Omowumi Ruth, 656,000. Hamid Aminat O 656,000. Afo Ayan Victoria 656,000. Ibitoye Saliman 656,000. Olalere Mary Olushola 764,000. Pashin Tola Thomas O 764,000. Alabi Abdul Kadir 764,000. Omolara G Kehinde 764,000. Yusuf Kabir 764,000. Abdul Rahim Afusat 764,000. Alabi Hadijat M 764,000. Nicholas Jegede 764,000. Adeyemi Olushola 764,000. Ayinla Idris 764,000. Akinyemi Agbola 764,000. Oyinlola F. Omolade 764,000. Ibitoye Adenike B 764,000. Adeoye Olabisi 764,000. Omonaye Kehinde 764,000. Ogunlade Shegun 764,000. Sadiq Olarenwaju S 764,000. Ogunjide B Olarenwaju 764,000. Amuzat Taufik 764,000. Afolayan Victor 1,220,000. Adewoyi Esther M 980,000. Yakubu Rahim 980,000. Garba Abdul Kadir 980,000. Abolade Samuel 764,000. Wole Oladebo 980,000. Tiamiu Lasis 980,000. These sums are to be paid within 30 days of this judgment, or the same sums, or the sums shall attract 10% interest per annum. This is the judgment of the court, and parties are to bear their respective costs. Judgment is entered accordingly.
Most obliged, sir. I thank my noble Lord for this wonderful judgment delivered, the industry and the time and the effort expended to deliver this judgment. May the Almighty God continue to sustain my Lord. Most obliged, sir.
That is
My Lord, we are grateful for the judgment.
Okay. My Lord, we are very grateful for this, for the judgment just delivered, sir.
Okay, thank you, gentlemen. The judgment is ready for collection today.
As God pleases, sir.
As God pleases. As God pleases.
Thank you. Thank you.
Lord, good morning, sir.
Good morning.
The faculty,
Ernest Silk,
good morning,
you
my
are
lord.
welcome.
My lord, we
Long
welcome
time.
your lordship back from that long journey.
Yes, me, I have finished
of-
my own. You people are still on your own.
That long journey that is
Yes.
full of stress
Of
and
election petition.
unnecessary abuses.
and misunderstandings and all that is negative.
Regrettably, social media has taken over Nigeria.
Yes.
So they think they think their opinion is law. Their opinion is never law. And the court did not ask them to come and file any action anyway. They brought the action.
They have become even more loyally than lawyers and judges.
My lord, it is the first time I've seen this since I've been privileged to know what election is from Penteco days. It's a shame. They abuse the judge, they abuse the lawyer, they abuse
up to CJN.
Oh, yes.
So who remain?
My lord, I was sincerely thinking, honestly speaking, I spoke with my learned friend in the office. I said, if I were a judge, I would just say they should invite one or two of them, give them 3 months imprisonment.
Anyway,
everybody will
Lanesuk, we are on air and we are being recorded.
I know, my lord. I was very pleased with that. My lord, we are interested in number AK01 2022.
Okay, that is
NICN/AK/01.
All right, appearances.
May the court be pleased. Temitope Mesheworun.
Temitope Mesheworun, Abi.
Lord, my learned friends, Ogun Sharafa Williams.
Williams.
A.O.
And who?
A.O. Odidiomo.
A.O.
Odidiomo. And D.A. Igbalajobi.
Who? T.A.
appears with me for the claimants.
Did you say T.A. or D.A.?
D as in Dan. D.A. Igbalajobi.
Yeah. I hope it's like this.
For the claimants, sir.
Okay. You people have gathered to show the Lanesuk. You can see the number. Okay. We have 1, 2, 3, 4. They want to match the Lanesuk.
I'm here, sir.
Yes, they want to pull you, to hold you to a standstill.
We are here.
All right.
It's a one-man army, sir.
With respect,
yes,
my learned friend Philip Joseph Esquire is with me for the defendants, first to third defendants. O Fakunle Esquire, sir.
You are with Joseph Caleb, or is it Caleb Joseph?
Me is my learned friend.
Is it Joseph Caleb?
Caleb Joseph.
Caleb Joseph.
Caleb T.C. Joseph. But we choose to fully announce it because I have a learned brother who is CIO Joseph. We are for defendants. Sir.
All right. Yes.
My lord, sir.
Yes.
On the last adjourned date, we informed the court.
Yes.
That we intend to reply the counter affidavit filed by the defense counsel, sir.
Yes.
Unfortunately, my Lord, it has been a serious thing in our office. We are unable to locate the file.
The file for this case.
Yes, sir.
Do you know that if we were in court physical, I would have disallowed you appearing before me because I don't take it. When counsel appears before me without file, I don't take it. Ask other counsel. You are lucky you are on Zoom. So let me hear you. Yes. You lost your file.
We are blessed with that fact, and in that circumstance,
wait, you lost your file. You lost your file. So what happened? Continue.
Yes, sir. And it has not availed us the opportunity to reply to the counter affidavits because we are unable to lay hold. Unable to lay hold on the counter affidavits, sir.
You have been able to find.
We are unable to lay hold on the counter affidavit on which we want to reply on point of law, sir.
Or you are unable to lay on the counter affidavit, isn't it? You said you are unable to lay on the
We are unable to lay hold on the counter affidavit that will enable us to reply on point of law, sir.
And that is because you lost your file.
Yes, sir. Yes, my lord.
Yes. And you went to the court registry and the file was lost also.
No, sir. We have been making
Okay, you
attempts.
chose not to go to the court registry.
We are taking that as an alternative mode which we are going to explore after this proceeding, sir.
From December 2022.
No.
From
January.
February 2023.
The last time we got that was in March.
That was the last date we, no. 8 December 2022. And we are in November 2023. You are still considering the option of going to the court to look for the copies from the court's file. You lost your file since before December 2022, and you have not gone to the court to get a complete CTC of the file. So what do you want? What do you want?
I want to passionately pray. We want to passionately seek the indulgence of the court.
Yes.
To grant us an opportunity to approach the court registry so that we can.
I don't need to grant you opportunity to approach the court registry. It's your right. It's not something you pray for. It's your right, fundamental right, or whatever you call is your right. The registry has always been open to you to approach it. So you don't need my leave. You don't need my order. Please.
We are praying the court to grant us indulgence of a short adjournment, sir, so that we can put our records straight. More so.
What is the stage of this matter?
More so, sir.
What is the stage of the case?
My lord.
It's an originating summons, sir.
It's an originating summons. Okay.
Yes, sir.
Lanesuk.
My lord, thank you so much, man. I'm surprised at this request by my learned friend. On the 12th day of January 2022, they brought an originating summons before your lordships. And we joined issue with the claimants on the 27th of January. We were in court, and when we came before your lordship, because of your lordship's busy schedule along the line, December 8th, they made an application that they intended to file to make a response. Since they have waived their right and they have not so done, I will urge your lordship to compel the claimant to argue their summons and the reply that we have made, so we can allow your lordship to rule one way or the other. The bones of this case is already tired. And using the words of your learned brothers of the Spirit Court in Iru and Urum, they should allow this matter to rest one way or the other. In the case of Bakari versus SB Bakari versus ACB Limited, which with your lordship's permission, I will quote 1986, 3 Nigeria Weekly Law Report, page 47. The learned brothers of the Supreme Court said, the nearness of the office of counsel to the court should not be the basis for seeking an adjournment. After 1 year, a learned friend has come to say to your lordship that he needs an adjournment to file a process. In fact, the reason given by
the claimants have no tenable excuse to ask for an adjournment today, as the case is ripe for hearing. The matter is
they have no tenable reason. Yes, tenable reason.
Lord, the matter is to proceed to hearing.
As God pleases. Thank you, sir.
My Lord, sir.
Yes. The matter is to proceed to hearing. That's the order of the court.
As God pleases. We are most grateful.
The claimant filed an originating summons on the 12th of January, 2022, sir.
Yeah.
We raised 2 questions for determination. Whether by section 4.1, section 4I.
Taken as read. Taken as read.
As the court pleases. I will further ask for relief, sir. Attached to the originating summons is an affidavit evidence of Temidara Samuel Fagbola.
How many paragraph affidavit?
27 paragraph affidavit, sir, of Temidara Samuel Fagbola, the first claimant in this suit.
How many annexures?
No annexures, sir.
Eh?
None, sir.
No annexures.
Yes, sir. My Lord, sir.
Yes, let's proceed.
My Lord, sir.
Yes.
We have an Exhibit A, the judgment of the National Industrial Court.
I thought you said no annexure.
I apologize, sir.
It's all right. Check. All right, let's proceed. I've seen it in the file.
As the court pleases, and in line with the rules of this honorable court.
Come, counsel, do you? Okay. You say you don't have the file. Because I can see more annexures in my
Yes,
file.
sir. We have four. Yeah. We have exhibit A to D, sir. Exhibit A to D.
Yeah, the file.
All right.
Exhibit A to D, sir.
All right.
And in line with the rules of the court, we qualify the written address.
Yes.
We adopt the argument contained in the written address as our argument in this case, sir.
Yes.
We urge your noble Lord to grant the claimant prayers in its entirety, sir.
Thank you.
We're grateful.
Learned sir.
My Lord, sir, most
Yeah.
grateful. We filed in response to the originating summons of the claimant, counter affidavit on the 27th day of January 2022 at the registry of your Lordship's court. The counter affidavit has in it 14 depositions on oath sworn to by Mr. Patrick Fasuon. And
Learned sir.
yes, ma'am.
I don't know if I am, pardon me,
Yes, ma'am.
if I'm doing the wrong thing. This matter was filed in January.
Yes, ma'am.
And you file your counter affidavit in December.
No, my Lord. January, sir. January, sir. The same month. The same. They served us with the process.
He said
on
you
the
file
18th
your
and
counter affidavit when?
27/1, my Lord.
Okay, 27 January
Yes, my Lord.
2022.
In fact, we filed it 5 days after service.
Okay, okay. I don't know. I thought you said 23.
No, sir.
Probably you mistakenly said 23 because that's.
I'm sorry about that. I said
you said
27th.
something that gave me the impression that it was a year after. That's why
No, my Lord.
I stopped you to call your attention.
Thank you, my Lord.
All
Sorry
right,
for this.
thank you. All right.
27/1/2022.
Okay.
My Lord, the affidavit of Mr. Fasuon has 14 depositions made on oath. We also exhibited to the affidavit
Yes.
2 documentary exhibits marked Annexure PF1 and PF2. PF1 and PF2.
All right.
My Lord, in addition, we made a reference to Exhibit D.
On the claimant's
on claimant's affidavit. Yes, my Lord.
Yes.
My Lord, following the rule of court, we filed along with our counter affidavit a written address, wherein we raised 2 issues. The Lordship's permission, we seek to adopt the
Why
written
are
address.
you raising issues?
My Lord,
you said you raised. You didn't say you adopted. You raised. Why are you raising issues? You are a defendant in an originating summons.
My Lord, that is the very essence of it. They brought
that's why I'm
summons.
asking you. I just want to get a grasp of it without even going through, so that I understand you as we're going along. Why did you have to raise issues?
We had to raise it. We had to raise it to bring it before your lordship clearly that in a situation such as this, whether originating summons can be used at all, and whether the matter is even justiciable. Those were
okay, that's more of like an objection.
Point we brought out in our address. Yes.
That is more of like an objection.
Yes, part of it,
isn't it?
Even though we are
yes,
yes, my lord. Even though we answered, yes, my lord.
Yes,
thank you, my lord. And we answered.
That's why I feel comfortable to ask people like you in proceedings like this, because you will go with me and we'll all understand each other. Thank you very much. That gives me a clearer picture.
My lord.
A clear picture.
Yes, my lord.
Yes.
My lord.
Yes.
My lord, permit me, my lord, to say that the claimant did not serve us with a copy of the judgment of your learned brother, Pastor Oyewumi, but we exhibited it to our affidavit, and that's what we marked as PF1, a certified true copy of the judgment.
The claimant, he said he attached judgment according to claimant. Look for that judgment. I'm confirming things from my file, even as you argue.
As copies, my lord.
That is his exhibit A. The judgment of Justice Oyewumi is attached to his originating summons as exhibit A. He said,
hello, we are most grateful. We are most grateful. What they did was to omit that in our copy, but we helped them to exhibit it. And we remarked it.
Oh, okay, they omitted it in your copy.
They did
That's
not give us in our copy, yes.
Yes, that's more correct because it is in the court's file as exhibit A.
We tried to search, so we went to get the copy.
And it seems that that judgment is so important to both parties that even though you had the impression that he did not exhibit it, you yourself had to exhibit it.
We exhibited it. Yes. And we made reference to page 27 of the judgment.
All right. Thank you.
So think it clearly that what his lordship said, what the learned brother said in that judgment is not what they brought out in their own paper.
All right.
Yes. My lord, before I ask for permission to keep quiet on this matter, permit me, my lord, to cite one case.
I think it is neater you adopt first, learned, sir.
Yes, I've done so, sir. I said that with respect, I adopt the
maybe address. I didn't hear you.
I'm sorry, my lord.
I stopped at, we also attached a written address.
Your lordship's leave, sir. We adopt the written address.
Thank you very much.
Addition to the counter affidavit and the documentary exhibits.
All right.
My lord, permit me to, before I start that case, to stress that the two documents referred to by the claimant,
yes,
which are letters. One is letter dated January 6, which we exhibited as PF2. And what they called Exhibit D. January 6 letter is a letter marked PF2 by us, which emanated from the claimant. Exhibit D is a letter dated January 10, which is a reply, is the reply to the letter of January 6. Both of them put together will show, my Lord, that the claimants themselves recognize the fact that, and using that language, they said it will be unwieldy to have all persons attend the meeting of congregation at all times. How was the language? He said, arising from the rowdiness that greeted the last meeting. So recourse was made to the power and the duty imposed on the Vice Chancellor to determine the number of persons that may attend a particular meeting of congregation at a given time. And that is why I said that the law put that responsibility on the VC. And that's the basis of the case I want to cite in addition to the last one I cited at the foot of our written address, which is Akintemi and Umikili. Permit me, my Lord, to cite the case of University
Just
of...
state the principle upon which you want to cite the case.
Yes, the principle is that the domestic affair of Utah,
yes,
in this matter,
yes,
may not be subject to cross adjudication.
Is what?
Because it's the domestic affair of Utah,
yes,
grounded upon law,
yes,
which enjoins the VC to determine how many people can attend a congregation meeting at a given time, cannot be subject to respect to judicial adjudication. It's not justiciable.
The VC to determine how many people
Yes, we
can
attend. Yes, ma'am.
And attend what?
The meeting of congregation at a given time.
It's not justiciable.
It's not justiciable in court because it is grounded upon a law which gives the VC, which imposes that duty on the VC. I mean,
see
the Vice Chancellor.
See what case?
The case of University of Uyo versus SL. SL, my Lord, is E capital SSEL.
Yes.
Reported in 2006.
Yes.
All Federation Weekly Law Report. All FWLR. All FWLR.
You have to send that report or
I will do so,
photocopy it and send it.
It's with me as I'm talking.
Yes. Either you give us the entire law report or you photocopy the relevant report and send it to the registry immediately.
I will do so today, sir.
Part
19, part 315, my Lord, 315.
Yes.
Page 80. At page 100.
Okay.
Paragraph C to E. Paragraph C to E. Courts
let me hear what it says.
Yes, sir. Your learned brothers, referring to Akintemi and Umejili, which I've cited, said courts do not
Court of Appeal or Supreme Court?
It's Court of Appeal adopting and referring to the Supreme Court case, which I earlier cited at paragraph 4.13.
Okay.
That courts do not, Honorable Justice Adamu just said, then courts do not interfere with the internal administration of a university. What amounts to the domestic or internal administration of a university is a matter of law. in that the various statutes establishing universities have from their inception defined their powers and their scope under the acts setting up the university. My Lord will recall that. Yes, sir.
Just a moment, Lanesuk. Just a moment, Lanesuk. What was the particular domestic affairs of the university referred to in the report?
Is the issue of congregation in our own case here?
No, in your report.
In the law report.
Yes. What was the domestic affairs in issue?
The general issue was that they set up a panel to look into an issue which bordered on criminality. And the Court of Appeal said no. It's only
that's disciplinary procedure.
Yes, my Lord. He now said no.
Okay.
You can discipline, but when it has the element of crime, you don't do that. But in our case, it centers on Article 4.1, bracket H, which gives.
Okay. That's all right. Understood.
Yes, my Lord.
Yes.
Yes, my Lord. My Lord, I urge your Lordship to dismiss these fuller reasons given in our written utterance. Dismiss the case of claimants, lacking in merit and substance.
All right. Thank you.
Lord, we are doing the copy of the judgment right away.
Case adjourned for judgment on a date to be communicated to parties.
Stop, please. My Lord, may I make this a very, very humble request, sir?
Yes.
My Lord, we got information from the registry of court. Your Lordship will see the matter which involves us on Zoom tomorrow. My Lord, before vacation, High Court number 4, Akure, in fact, that was why I came back, had given us 2 matters which are patterned, which will be continued tomorrow. There are 2. One has been on since 2012, involving a communal land, and the other one borders on economic issue. And, a central
Yes. I'm listening.
bank official has been spent enough or happily our tomorrow. So I'm praying your Lordship to inner by indulgence, my Lord. So allow us, if such a thing can be done, that we can take another date, not.
Have you sent a letter for adjournment? Honestly, you did not send letter for adjournment. Please.
My Lord, we just saw the thing yesterday that will be that there is Zoom for tomorrow.
It was not adjourned yesterday. What you saw yesterday was a reminder and to give you the Zoom particulars.
Lord, I'm very
just
sorry.
A reminder aimed at giving you the Zoom particulars.
My Lord, the first time, the date I was given to us before was not 29th, my Lord. That's why I said, so yes, I tried to even get, and that is, we were given November 6th. Oh, the day we were given, November 6th.
November 6th. Write your letter, submit your letter for adjournment. Submit your letter for adjournment. Okay, before I tell you that Caleb can be on Zoom while you go to court with other lawyers.
My Lord, we are the 2 people on ground now. The others
How can we? Where have the others gone to?
My Lord,
where have the others gone to today and tomorrow?
Lawyers don't want to. My Lord, we have an office in Abuja, for instance. Lawyers don't want to do litigation anymore. are begging them now to join.
No, I have lawyers in Jos who want to do litigation. In fact, you can confirm from Caleb. We have lawyers in Jos who are ready to do litigation.
My Lord,
so if you want, you can ask Caleb to bring some lawyers for you from Jos.
My Lord, that's very welcome, because a colleague of mine, Mr. Morgan, had to send a message to me that can I come to Soko to Kano. So, you know, it's becoming more tedious now because
all these new lawyers that they are rolling out from law school everywhere, where are they going? Are they all going to Central Bank or refinery?
Majority of our young lawyers are being discouraged by our uniqueness in our system.
The discouragement is everywhere in the legal system, up to the judges. There is discouragement everywhere. But we must survive. We must be seen to be doing something to survive and contributing our quota to the development of the nation.
When I came to legal profession, a little over 40 years now of practice, our salary was 415 naira. We could not even rent a flat.
Let us think. I remember we talked about this in court. When I was saying I started with a salary of 3,000 and you were saying, my own was too much, that yours was 450. So I said, if you started with 450, then I should not complain that I started with 3,000.
Our own was 415 naira. And it was never paid as I went due.
Okay, just do your best. Send us a letter. Send a letter. Just send a letter.
In order not to waste the time of God, I will do so now.
Thank you.
Thank you so much.
Very much. Thank you.
Thank you, my Lord.
The next matter is Dr. Idigbe Ajisafe and Federal University of Oye Ekiti. Any appearance?
With due respect to my Lord,
yes.
My name is Ademola Olowoyeye. And with me, Olukayode Ashaolu.
Wait, Ademola
Olowoyeye. Olowoyeye.
With
Olukayode. Olukayode. Ashaolu. Ashaolu, sir. You humbly announce our appearance for the claimant. OLU, sir. OLU.
For the claimant.
For the claimant, sir.
Is it one claimant? Yes.
It's just one claimant, sir.
Yes. Who appears for the defendant? For the defendant.
My Lord.
Adegboyega. Or is it Adegboyega or
Adegboyega, sir?
Yes. And O.I. Laditi. None of them is online?
My Lord, Adegboyega called me in the course of these proceedings to say he's having a problem being online. I don't know what that means.
It means either his network is bad or he is just not good with Zoom. One of the two.
My Lord, sir.
Yes.
With greatest respect, sir.
Yes.
I am T.S. Adegboyega. My Lord, appearing with me are my learned friends, sir. Olugbenga Fayemiwo, Esquire. My Lord, I also have with me Faith Atama. Olugbenga Fayemiwo. And Faith Atama, Esquire. Faith Atama, A-T-A-M-A, as pronounced, sir.
Yeah.
And E.A. Okunola, Esquire. Most humbly, we appear for the defendants, sir.
Yes.
My Lord, it is true. I called my learned senior today that we had an issue with the network.
I've seen you before now.
Yes, sir.
I've seen this team before now.
I have.
You have been online.
Yes, sir. My Lord, I'm grateful, sir.
Yes. This matter is for what today?
It's for hearing, my Lord, if the business of the court permits, sir.
Is it hearing or continuation of hearing?
It's hearing, first attempt at hearing, sir.
Okay. Is it a complaint or relating someone?
No, it's a writ of summons, sir.
Writ of summons in NIC.
I mean complaint.
It's a complaint.
Complaint, sir. And it's our process is amended general form of complaints dated 29th June 2022, sir.
Yes.
And we also have reply. It's for hearing, sir.
Yes. So,
okay, sir. My client is here, sir. Dr. Akingbe.
You are ready?
Yes, I'm ready, sir. Very ready. Yes, sir.
This is the process, right?
Yes, sir. Yes, my Lord. Yes, sir. Yes, sir.
Compliant.
Yes, sir. 29th
I said
of June.
the process Zoom compliant.
Yes, sir. It is Zoom compliant, sir.
What does that mean?
Possible. Sure. Mickey to the value of the kingdom.
Let me show you something about why I say it's Zoom compliant.
Okay.
In witness statement, you actually have this statement saying, I shall rely on the internal memo dated. I shall rely on the document dated But you did not say it is hereby attached and marked as exhibit so. In other words, it is not sworn with your witness statement as an annexure. You have just
It was,
attached them. You have just attached them as part of the complaint. Not that you have sworn and attached to. You have attached them to the witness statement and sworn them on oath.
my lord, the date of the amended general form of complaint is 29th June 2022.
Yes.
And the sworn statement is also 29th June, sir, 2022.
Listen to me,
And
we
did it.
just listen to me, counsel. You know, the rule says you should front load the documents you are relying on, isn't it?
Yes, my lord.
You can simply front load them, attach them to your process. That
Yes,
is
sir.
just front loading in compliance with the rules of the court.
Okay.
But to make it Zoom compliant, you need to attach those exhibits, particularly to the witness statement that made reference to them, so that it is deposed. So those documents are deposed on oath. In which case, they don't need to be tendered again. They are already before the court on oath. So which one have you done?
My lord, that is exactly what we did, sir. That was exactly what we did, sir.
Which one? What exactly is what you did?
We swore to an affidavit evidence that called the amended witness deposition on oath, sir. The same date that we filed the amended statement. And the witness
statement, in the witness statement,
yes, sir. Yes, sir.
You attach the annexures to the witness statement, or you attach the annexures generally to the complaint?
It was attached to the witness statement, my lord. At least it is referable, sir, to the witness statement, sir, to the annexure, sir.
It is referable. That's why I said it's half compliant. You remember I even read what you have said.
Yes, sir.
I even read what you have said. But you did not say it is hereby attached and marked as exhibit so in your witness statement.
Oh.
But you made mention of the exhibits in your witness statement, which is, of course, that is the normal thing. If you just attach the annexures to the complaint without referring to them in your witness statement, of course, you know that they will not be admitted. So, but
no, my lord, we clearly clearly marked the exhibit.
Yes, you have marked them. I have seen it. I've seen it. But the way it is not attached and deposed to as and that is the exhibits are not before the court on oath. Which means you have to tender them. You have to tender them and for them to be admitted and marked.
Okay, sir.
You understand?
So I should
tender them so that they will be admitted and marked as it is now. But if you had referred to them as exhibits also and attached them to the annexure, which means they were deposed on oath, then you don't need to tender them anymore. That will make it fully Zoom compliant. We can take you on Zoom. But now that you need to tender the documents, it will be very difficult for us to do now on Zoom. That's what I'm trying to
then re-swear.
Of course, you can.
Can I now take some time to?
Yes.
Okay, sir.
So that we can do it.
May I seek my lord's indulgence to go and refile our witness deposition?
Yeah.
Yes.
Any objection?
My Lord, we will not be objecting, sir, because it appears our process suffers similar fate.
All right, so you will take a cue.
Yes, sir. And we
You
will
will take a
equally be
cue
asking
and do the same thing so that we can do everything on Zoom. You don't need to come to my court. I don't need to.
Exactly, sir.
We only
Most
interact
grateful,
on
sir.
air, and we get
Yes,
our
sir.
judgment.
Yes, sir.
Yes.
My Lord, I
Yeah,
thought
and for you to
it
read my
was.
judgment, you don't even need to come to court for a physical copy. You can read it
As
on our
God pleases, sir.
platform.
My Lord, we are grateful for
This is
that
where the
instruction,
money is
sir.
going.
We
We will
are
do
really
the
grateful
needful
for
and refile our own statement on hold as well. Attach the exhibit and be
Yes.
sworn on hold, sir.
Thank you very much.
Thank you very much, sir. So may we be guided, sir, as to dates. Dr. Akinwumi.
So the court was saying,
How do I
I
go
said
back?
first adjourned to 1st February 2024 for hearing by Zoom.
As the call pleases, sir. Very much obliged, sir.
Thank you.
And I wish my Lord
we are grateful, sir.
Merry Christmas and Happy New Year, sir.
Thank you very much.
2024.
Why I adopt the position of my learned senior, I equally welcome my Lord back from the national assignment, sir.
All right, thank you very much. We will welcome you people back maybe by January or February when the Supreme Court has finished. Then we welcome you people back.
Thank you, sir.
2020.
Okay, hold on.
Appearance.
Hello.
no, more sir.
Hi. One instead of carry far.
Cancel,
We should
cancel.
also.
Hey, please.
Sorry,
mute
sir.
your mic. Mute your mic. You are on a call while you are online.
I'm sorry, sir. I'm sorry, my lord. I'm sorry.
Mute your mic, please. Yes. AK 30 2020. 2022. Any appearance?
May your lordship be pleased.
Yes. Are you sure this is your case?
Yes. AK 30 2022, sir.
Okay.
Temitope Meshiwon. My lord, my learned friends. Ogun Sarafa Williams. A.O. Odidiomo. And D.A. Igbalajobi appears with me for the claimants, all the claimants, sir.
A.O.
Odidiomo, O-D-I-D-I-O-M-O. Odidiomo.
And who?
And D.A. Igbalajobi. D.A. Igbalajobi appears with me for all the claimants, sir.
Yes, who appears for the defendants?
May it please my noble lord.
Yes.
I am O.O. Akinlabi. I am the DDCR, Deputy Director, Citizens' Rights, Ekiti State Ministry of Justice. And I appear for all the defendants. The four of them, sir. I'm very grateful, sir.
Yes.
My Lord, the matter is stated for hearing, sir. Subject to, it is an originating summons. Subject to overriding convenience of the court. We are ready, sir.
Yes, my Lord. I am ready, sir.
Okay.
I'm equally ready, sir.
Unfortunately, I think I have adopted. It may not be convenient, but since all the processes are in, I'll see what I can do before the day for adoption, if I can. But I'll give you a January date for adoption.
As a couple.
Mm. 31st January 2024 for adoption by Zoom.
Beg your pardon, my Lord.
31st, 3/1,
Convenient, my
As the
Lord.
January
As the
2024
couple.
for adoption by Zoom.
As the couple, sir.
As the couple.
for 2022, Dr. Agati Awozo and Landmark University. Ayenakin. I can see Banjo Ayenakin.
My Lord, sir, we are from the firm of Banjo Ayenaki, sir.
Okay.
Yes, sir.
All right. Yes, who is in this matter? IL 04 2022. Who appears? L.O. Bello, Abiodun Dada, L.O. Bello, and Abiodun Dada, none of them.
My Lord, we are here.
My Lord, I'm with you, sir.
And I'm adjourning your matter. You are here. Are you I.L. Bello or Abiodun Dada?
My Lord, with respect, my Lord, L.O. Bello, sir.
Which one is your own case?
The case of Dr. Agaptos Inwosof and Landmark University.
And I am calling the matter and almost adjourning. In fact, I've recorded no appearance for either party. Case is just dead. I wanted to fix.
My Lord, I'm very sorry.
We are so sorry, my Lord. The network
and both of you are on Zoom watching.
Yes, my Lord. We are sorry.
You know, we are very.
Please announce appearance.
May your worship
is L.O. Bello is my name. Lord, with greatest respect, I announce my appearance for the claimant applicants.
Yes.
With kind permission of the noble court, sir, I announce my appearance for the defendant respondent. Abiodun Dada is my name. And I appear with my learned friend, Israel Isaac Adekunle. Isaac Adekunle. For the defendant respondent, my lord.
Learned counsel.
Thank you, my lord, sir.
This proceedings is being recorded live, so please speak only English and avoid side talks.
Ask up, please.
L. Bello.
Thank you, my lord. L.O. Bello, my lord, sir.
L.O. Bello.
Thank you, my lord. L for Lukman, sir.
Yes.
Thank you, my lord, sir.
Wondering, are you sitting in your living room?
My lord, with great respect, I am in Abuja, I'm not in Kwara. I came for MD, SAN investigators, and I'm in my service apartments.
Okay.
So, my file, sir.
It's all right. It's all right.
Thank you, my lord, sir.
It didn't look like an office.
Thank you, my lord, sir. My lord, we have a for amendment of our form of complaint and statement of facts, sir. The general form of complaint which we seek to amend is dated 30th day of May 2022, and we will file our application on the 4th of March 2022. Subject to the overriding confidence of your learn
to listen to the court too. The motion is dated.
The motion is dated 28th day of 2023, my lord, sir. 28.
28 what?
28 February, my lord. 2023. And for the 1st of March 2023, sir.
For amendment of your processes, isn't it?
Yes, my lord, sir. Thank you, my lord, sir.
Where did you file the process?
My lord, it was filed on the 1st of March 2023, sir.
Where did you file the process?
We filed it at the National Assembly, National Industrial Court Registry, Ilorin.
It has not yet reached our file.
Wow.
Yes, that's right.
Do you have 2 volumes of file?
Lord, we only have one.
Okay, that process you filed at Ilorin has not yet been brought to Akure. Maybe you did not, I don't know.
Lord, we have done what we should do on our parts.
Have you done that?
Yes, my lord, we were served with a copy of that application.
Okay.
And consequently, we will file our counter affidavit against the granting of the said
Your counter affidavit has reached us. It is in the file. The counter affidavit is in our file.
As places.
You file your counter affidavit where?
It was filed at the registry of your lordship court in Ilorin.
Yes, but it has reached us, but the main process has not come.
Wow.
So what do we do?
My Lord, the circumstance, we shall be seeking for a very short date of adjournment to enable us make an inquiry at the registry to know what has really, what has really gone wrong, my Lord, sir. Because we have done all the necessary things that we are supposed to do.
Case adjourned to 30 January 2024 for hearing.
Sorry, my Lord. January 30th.
Yes, 30.
Thank you, my Lord.
We are grateful.
Any other matter? Is anyone online with waiting for his case?